Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and the decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions are those of the speaker.
Hello, and welcome to SCOTUScast. I'm your host, Kyle Hammerness, on behalf of the Faculty Division of the Federalist Society. We are here today to discuss Glossip versus Oklahoma, which was decided by the court in a 5-3 decision on February 25, 2025. It is my honor to introduce our guest today, Zack Smith. Zack is a legal fellow and manager of the Supreme Court and Appellate Advocacy program in the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. He previously served for several years as an assistant United States attorney in the Northern District of Florida. Prior to that, he spent 2 years as an associate in the Washington, D.C. office of Clearly Gottlieb Steen and Hamilton, which he joined after clerking for the Honorable Emmett R. Cox on the United States Court of Appeals for the 11th Circuit. And with that, I'll hand things over to Zack to get us started by talking about how the case got to the Supreme Court.
Well, thank you so much for having me on the show today. And I think it goes without saying, it's always a pleasure to be able to do these types of events. And look, the Glossip case is very unique in a number of respects, particularly in terms of its very tortured procedural history. This is not a case that has gone through the essentially normal appellate process and is at the court. It's gone through an extensive period of litigation on direct appeal and then also on collateral appeal as well. And so to go all the way back to the very beginning, this case started in 1997 when Justice Snead murdered Barry Van Treese. Barry Van Treese owned 2 motels, one in Oklahoma, one in Tulsa, and Justice Snead was working at one of those motels along with Richard Glossip. Now, Glossip managed one of those motels, and the facts underlying this entire the background of the murder are somewhat in dispute. But essentially what happened is Van Treese showed up at one of his hotels, and while he was there, Snead murdered him. Now, Snead later came out and said that Glossip essentially solicited him to murder Barry Van Treese, and Glossip was worried that he was going to be fired by Van Treese, allegedly for maybe some financial improprieties. And this meant that Snead himself would probably end up homeless because he too was living at the hotel. Now, in the wake of the murder of Van Treese, in the immediate aftermath, Glossip said he didn't know where Van Treese was. He said he had seen Van Treese the next morning after he had been murdered. He spoke to Van Treese's wife on the phone, assuring her that everything was okay. And it turned out, of course, that just wasn't true. And it wasn't until several days later that a police officer showed up at the hotel and found Van Treese's body in one of the rooms, which, by the way, Snead and Glossip had replaced broken glass in the room to try to hide the crime. And so what happened, police arrested Snead. They later arrested Glossip as well. And they initially charged Glossip as an accessory after the fact of the murder. But after talking to Snead, getting more factual information, they also charged Richard Glossip with capital murder, essentially for soliciting Snead to commit the murder. Now, in terms of the trial, Glossip was originally tried and convicted in 1998 and sentenced to death for his role in Barry Van Treese's murder. But because of an ineffective assistance of counsel claim that was brought, the Oklahoma Court of Criminal Appeals, which is the highest criminal court in Oklahoma, sent the case back for retrial. So Richard Glossip was retried, convicted once again, and once again sentenced to death after a trial in 2004. And so it's the proceedings of that 2004 trial that are really at issue in this collateral appeal. Now, since his conviction in 2004, Glossip, as I mentioned earlier, has taken a number of direct appeals. He has filed a number of collateral attacks on his sentence. And so the collateral attack that the Supreme Court considered and ruled on was actually his 5th habeas petition that he had filed with Oklahoma's court system. So it's a long and tortured history that this case took to ultimately end up at the Supreme Court and for the court to issue its decision.
Great. Well, thank you so much for providing that really necessary background. because it does seem a bit complicated. So I guess as we turn toward the oral arguments and which arguments each side was making, can you go a little bit more into that and kind of um, give us a clear picture of where each side stood?
Yeah, so as part of its tortured history, along the way, the Oklahoma legislature essentially responded to some of the political pressure it was receiving and commissioned a law firm, Reed Smith, to write a report about whether certain things had been turned over appropriately to Richard Glossip's counsel during the trial, to flag any other issues with the trial. And so Reed Smith wrote the report and issued a report flagging a number of issues, particularly as it relates to some evidence that they alleged wasn't turned over, particularly as it relates to some testimony that came out at trial. And so, what ultimately happened is shortly after Reed Smith wrote its report, a new Oklahoma Attorney General also took office. Now, the Oklahoma Attorney General who took office, he turned over additional evidence to Richard Glossip's counsel, which prompted the filing of this fifth habeas petition with the court. And along the way, he turned over an eighth box. There were seven boxes originally that he turned over. He turned over an eighth box as well, which contained some handwritten notes from the prosecutor that tried the case. And so after he turned over this eighth box, Richard Glossip's counsel was alleging that Justin Sneed, remember the man who actually murdered Barry Van Treese, offered what Glossip's counsel characterized as false testimony at trial. Essentially, Justin Sneed, he had mental health issues. He'd been prescribed lithium to deal with bipolar disorder. And at trial, one of the questions to ask was whether he had ever been prescribed lithium. And he said yes, he took lithium, but he said he took it either in the wake of a toothache or that he had been inadvertently prescribed lithium because he had a head cold and was supposed to get Sudafed. Now, everyone knows the only reason someone would be prescribed lithium is for mental health issues. But the fact that the prosecutors didn't go back and clarify that, Glossip said that was false testimony that essentially had been left uncorrected, which would be a violation of the Supreme Court's holding in Napue versus Illinois. So the Oklahoma Attorney General, he actually conceded error. In front of the Oklahoma Court of Criminal Appeals and asked for Mr. Glossip's sentence to be vacated and for Glossip to receive a new trial. Now, for state procedural reasons, Oklahoma has like many states, like the federal government, has a statute that governs when a prisoner can bring a successive habeas petition. And essentially, the Oklahoma Court of Criminal Appeals said that Glossip hadn't met those very strict procedural requirements, particularly because much of the information that now is being disputed could have been discovered by his attorneys much, much earlier in the process. And they certainly had access to much of the underlying information about these issues. But nonetheless, Oklahoma's Attorney General conceded error. Now, it's interesting when the case came to the Supreme Court, because Oklahoma's Attorney General had conceded error below and actually supported Mr. Glossip's efforts to get a new trial, the Oklahoma Attorney General was lined up on the same side as Richard Glossip. What this meant is that the court had to appoint an amicus, someone to argue on behalf of the state to actually uphold the integrity of this conviction. And I think the individual the court appointed did a very good job at that. At the oral arguments, it was clear the justices were divided on exactly how to deal with this issue. And there were really two substantive issues the court was grappling with at argument. And I think you see that coming out in the opinion is one, whether the court even had the power to hear this case. Because if there's an independent and adequate state ground where a state's highest court reaches a decision, typically the US Supreme Court will not have the ability to hear that case. So that's the first procedural issue. The second issue the court was being asked to consider was whether, in fact, this new information that came out constituted either a violation of Napue versus Illinois, whether there's false testimony that the prosecution left uncorrected, and also whether there was a violation of Brady, where essentially prosecutors have to provide exculpatory evidence to criminal defendants.
Great. So I guess that sets us up perfectly to talk about the opinions. There were three opinions that were released by the court. The first was the holding opinion, the majority opinion by Justice Sotomayor. Can you touch a little bit about how she ruled and the reasoning behind her ruling?
Yeah, absolutely. And I think it's interesting at the outset to note that Justice Neil Gorsuch didn't participate in this case. That's likely because while he was a judge on the 10th Circuit Court of Appeals, previous iterations of Mr. Glossop's case came before the 10th Circuit. And so Justice Gorsuch didn't rule at all or could take any part in the consideration of this case. Now, Justice Sotomayor, in her opinion, that was joined by everyone except for Justice Alito and Justice Thomas, and joined in part by Justice Barrett. And we can talk about that more in a minute. But essentially, Justice Sotomayor said that the procedural bar to the case, there was not an adequate and independent state ground for the court to avoid ruling on the case. And the reason she did that, and I agree with Justice Thomas, her rationale was somewhat convoluted on this respect, but she said because the Oklahoma Court of Criminal Appeals, essentially in the process of deciding the state law procedural issues, had to reject Mr. Glossop's Napue claim, which would be a federal claim, a claim arising from federal law, that a adequate federal ground existed essentially to allow the court to take jurisdiction. Now, the reason a Napue claim is a federal claim is because essentially the court said in that case that the 14th Amendment's due process clause requires that prosecutors essentially not knowingly solicit or allow false testimony to stand uncorrected, particularly when it can have a material impact on the jury's verdict. So that's the first thing Justice Sotomayor said. She said the court had the jurisdiction to take the case. And then when she got to the merits of the claim, she never ruled on the Brady violation issue, whether exculpatory evidence was not provided to Mr. Glossip and his defense team. And the reason she didn't rule on the Brady claim is because she said that the Napue claim would resolve the case. And so, again, for the reasons we've talked about, she said that essentially this testimony about the lithium, Justin Sneed taking it, why he received it, that was sufficient to raise a successful Napue claim in this circumstance. And a lot of the discussion between the majority and the dissent turned around some very cryptic handwritten notes that the prosecutor in the case had made concerning Mr. Sneed's lithium, maybe a doctor at the prison that had prescribed it. And there are different interpretations of what that meant. Certainly, the notes were, kind of very quick scribbles you make typically during a meeting. Justice Thomas actually appended an image of the notes to his dissent so everyone could see just how cryptic they were, in fact, and maybe not as clear cut as Justice Sotomayor suggested in her majority opinion. But because there was this Napue violation, according to the majority, the court then ordered a new trial for Mr. Glossop. And this was a major point of contention with Justice Thomas in the dissent, essentially saying that this was not the correct remedy. And this is where Justice Barrett disagreed with the majority as well. She said Justice Barrett, Justice Thomas, and Alito essentially took issue with the court ordering a new trial for Mr. Glossop. And part of the reason Justice Thomas and Alito in particular took issue with that is because of the role of the U.S. Supreme Court versus state Supreme Courts, or the state's highest courts, where typically, because the Supreme Court does not exercise the same supervisory authority over state Supreme Courts that it does over lower federal courts, that typically, whenever the U.S. Supreme Court reverses a state Supreme Court's decision or the decision from a state's highest court, they'll simply send it back for further proceedings consistent with this decision. In this case, that usually would have meant something like an evidentiary hearing would have needed to take place. And so essentially, this ruling that a new trial is required, Justice Thomas, Justice Alito, and Justice Barrett all argue that this was an inappropriate remedy, something that was beyond the court's power to issue. And yet that's what Justice Sotomayor and the majority of justices ordered to take place in this case.
Okay, so great. You covered every single opinion.
Covered the
that was
waterfront
really
there.
good. And I think I was, when I was looking over the case, I did note that Justice Barrett did concur in part and dissent in part. So thank you for clearing that up for us. I guess let's turn to what are some of the ramifications do you see due to this case going forward for other cases? How do you see this changing the body of law?
Well, it's hard to say exactly at this point. I think you are going to see more potentially habeas type petitions coming out. Certainly, a lot of this interplay between what exactly is an independent and adequate state ground, particularly in the habeas context, that has been significantly muddied. I suspect the court will have to address that again at some point in the not too distant future. And then also, I think what remedies the Supreme Court can order when it reverses a state Supreme Court's decision, that is something that is going to have to be determined in the future as well, because obviously this order of a new trial, as Justice Thomas pointed out, is a somewhat very aggressive assertion of power by the U.S. Supreme Court, and we'll have to wait and see what happens in future cases if the court continues down this path of ordering very specific relief, or if it will simply continue to remand the case for further proceedings consistent with its decision. The last thing I'll note, one of the interesting shout outs from Justice Sotomayor's opinion, and I think was underlying a lot of the discussion, but never really explicitly talked about, was an amicus brief that Paul Cassell filed. Now, if you don't know Paul Cassell, he's a professor at the University of Utah. He's a former federal judge himself, and he writes a lot on crime and criminal justice, and particularly, he writes a lot in the realm of victims' rights. And he actually filed a very powerful amicus brief on behalf of Barry Van Treese's family, highlighting some of the problems with the position the Oklahoma Attorney General, the Reed Smith report, and many other previous iterations of this case had taken. And he was arguing that Mr. Van Treese's family hadn't really received adequate opportunity to participate in this case. He was also arguing that essentially those handwritten notes, he very much agreed with Justice Thomas that they certainly didn't constitute, Brady violation or Napue violation. But if folks are interested in doing a little bit of a deeper dive, particularly on how victims' rights statutes often interplay with some of these criminal cases, Paul Cassell's brief is a very excellent explanation of kind of the background and some of the larger picture items related to these types of cases.
Okay, thank you for the recommendation. I'll definitely check it out. I guess just one more question, because you talked about how the court chose a specific remedy.
Yeah.
Have they done so before in the history of the court, or is this something completely new that we haven't seen?
Well, according to Justice Thomas, this is a very aggressive remedy that the court typically, and to my knowledge, has not done before, even in these types of cases. And it's hard to say why the court chose to take this path. Obviously, the Oklahoma Court of Criminal Appeals essentially overruled essentially the Attorney General's confession of error and said that the court has a duty to decide for itself whether an error has been committed. So I don't know if the court was essentially worried that the Oklahoma Court of Criminal Appeals might not issue the specific judgment that it wanted, the justices wanted it to issue in a case, which of course is certainly its prerogative as a separate and independent court exercising separate sovereign authority aside from the Supreme Courts. But yes, according to Justice Thomas and even Justice Barrett in her concurrence noted, this was a very unusual and very aggressive remedy that the court ordered.
Great. Well, thank you so much, Zach, for joining us. That was really excellent. I'm glad you were able to clear some of the muddy waters there in this case. Thank you so much for joining us.
Of course, thank you for having me on.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers. Founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is essential to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.